These are the key cases that have helped establish our defenses against libel. So it's important that you read through these cases and kind of study them so that you understand what the impact's been. So the first case we're going to talk about is the Hurst versus Capital Cities Media Incorporated, and this had to do with Hurst as a suspect in a rape, and the newspaper reported that he'd been questioned for 2 hours by police. Now, neither the police nor the suspect would comment, but the article said that the victim knew her attacker, the police didn't think it was a serial rapist. Ultimately, Hurst wasn't charged with the crime, but he sued Capitol, saying that there was false light invasion of privacy, that because he was identified and now he was basically connected with this case, that he was unfairly scrutinized. Now, what the court held was that the media truthfully reported the information that public officials had given them. And so even though that information placed him in a false light, that he was not indeed the person who had raped this woman, that if the information was given by an authoritative source and the media reported accurately, even if that information ends up to be false, the media is protected. So what the court determined was that there was criteria by which you could use a false light libel claim. One of them was that the suspect having been placed in a false light before the public as a result of the defendant's actions, and that the false light in which he was placed would be highly offensive to a reasonable person. So being accused of being a rapist is certainly highly offensive. But we have to prove that the information was disseminated with reckless disregard for the truth, recklessly publishing it without any real regard for whether or not it was true or not, and they didn't find that in this case. Now, another really significant case that we have to look at is Cherry versus Des Moines Leader, and what this does is set us up for the protection that comes with opinion. So the Cherry sisters were quite famous in the late 19th century. They had this vaudeville act, but there was a review of their performance that was less than complimentary. So here's an example. Effie is spavined, Addie is knock-kneed and string-hauled, and Jessie, the only one who showed her stockings, has legs with calves as classic in their outlines as the curves of a broom handle. Not even in the woods around Sac City nor in the wilds of Monoma County could 3 such raw and rank specimens of womanhood be found. So this review was printed in the Des Moines Leader, and there was a defamation suit that was filed by Addie Cherry against the newspapers. Now, what the verdict originally said that is basically, even if a performer disagrees with a viewer's characterizations, public performances invite comment and they invite criticism that you may or may not agree with. So this was a First Amendment offense, and basically the idea is that anyone who goes up on a stage who exhibits themselves in public has to be open to scrutiny, and even though that scrutiny may cross over into ridicule, there's still the right of the viewer of a public display like this to offer their opinion. Now, another case that we had that was influential in shaping how we understand libel was the Ollman versus Evans case. And the situation here was that Bertel Ollman was offered the job of the Department of Government and Politics at University of Maryland, but 2 columnists, syndicated columnists, Roland Evans and Robert Novak, who later became infamous in the revealing of the identity of Valerie Plame in a case that led to, we discussed a little bit earlier because it led to Judith Miller going to jail for not revealing her source. But basically, at the time here in 1977, he and Evans wrote a column that appeared in the Washington Post and other papers that said a Marxist professor's intentions, and quoted whether Ollman was qualified to get this position. Now, Ollman claimed that the column ultimately led to that position, the opportunity being withdrawn for him, and he sued for $6 million. Now, in a case that was heard by the D.C. Circuit Court of Appeals, led by Ken Starr, who you may know became famous for his investigation of President Clinton, they found 6-5 in a pretty split court, but they found for Evans and Novak, and what they established was what we now know as the Ollman test. So in order to determine whether or not something is libel in this regard, as it's printed in an opinion column, is the information, the statement, verifiable? Is it objectively able to be true or false? What is the common meaning of the words? What is the journalistic context in which the words are published? You have to kind of consider this column rating as a whole. And what's the broader social context in which the statement fits? Now, one of the protections that we get is a pretty noteworthy case, and it comes from the gentleman that we see here, who, of course, is the publisher of Hustler magazine. So let's take a look at rhetoric, parody, and satire, and how they can provide protection against libel. So the question becomes, can you trust something? And can you really believe that something is true? So the case that we have here is about Jerry Falwell, and Hustler magazine ran a parody ad for this Campari gin. And Campari gin had this ad campaign where they talked about people's first time drinking Campari gin. Well, the parody that they ran in Hustler had to do with Jerry Falwell talking about his first time. He was a very significant leader in the evangelical movement, and his first time was having sex with his mother. Now, ultimately, he ended up suing to recover damages for libel. He originally won a verdict of $150,000, but Hustler appealed the case. And the question was, freedom of speech protection, does it extend to the making of patently offensive statements, resulting in suffering emotional distress? And in fact, the court found unanimously for Hustler. And the reason is that this was determined to be parody, and no reasonable person would have assumed that this was truth about Jerry Falwell. And so it became protected speech, and this is what established the criteria of parody as protected speech. Now, the last case we're going to look at here that I need you guys to know about is the National Audubon Society, the case of Edwards versus National Audubon Society. And basically, they reported in their magazine, American Birds, that there were scientists who were being paid to lie by pesticide companies regarding the effect of pesticides on birds. So the New York Times wanted to write a story about this, and they were going to quote sources on both sides. But the scientists ended up suing for libel. And the verdict, as you might be able to guess, even though the information may not have been true about the scientists, the fact that the controversy existed and the lawsuit existed was factual. And so the New York Times reporting on this lawsuit was true reporting, and it was accurate reporting. And so this idea of democracy being served by a dialogue of ideas and these court proceedings could lead to government action, that accurate reporting was certainly protected by the First Amendment.